Hey everyone, this is the third video in this series on shareholders agreements. Today we're going to talk about the directors clause that is usually found in a shareholders agreement. So the directors clause should specify the maximum number of directors in the company. You should also state how many directors a party is entitled to appoint. For example, Party A is entitled to appoint up to 2 directors. Party B, who holds more shares, is entitled to appoint up to 3 directors. The director clause should also state that each director is entitled to appoint an alternate director. The clause should go on to state that the chairman of the board shall be appointed by the board or by a shareholder who shall have a second or casting vote. This is for situations where the votes are equal, for and against, and so you need a second or casting vote. You should also state that the right to appoint a director shall include the right to remove such director from office at any time. And whenever a person ceases to be a director, the shareholder who has appointed him has a right to appoint a new director as his replacement. The director clause should also include a quorum. What is a quorum? A quorum is the minimum number of people that has to be in attendance at a meeting before the meeting is valid. So for example, the clause can say that the quorum for any directors meeting shall always be 2 directors. You can also say the quorum for any directors meeting shall be 3 directors, one of whom must always include Director A appointed by shareholder A and Director B appointed by shareholder B. It is also wise to state how often directors meetings are to be held. Once every 3 months to report on the business and financial status, including the profit and cash flow position of the company. It's also important to include a clause stating that meetings have to be given a certain number of days, specifying the date of the meeting, the time and the place of the meeting, and this notice of meeting has to be given to each director. Questions arising from any meeting can be decided by a majority of votes cast at the meeting. In the case of equality of votes, that means some are for the resolution, some against, the chairman of the meeting will have a second or casting vote. Where a physical meeting is not held, decisions can also be made by way of directors' resolutions, written resolutions. So the director clause can also provide that decisions can be made by way of resolutions in writing, signed by a simple majority of the directors for the time being entitled to receive notice of meeting of the board. So for example, if the company is going to enter into a $1 million contract, there are 5 directors, okay, and 3 directors sign the written resolution, then the company is authorized to enter into that agreement. It is common in shareholders agreement to have a list of reserved matters. In other words, things that the company can only do when you have the unanimous consent of shareholders. But sometimes for some companies, they allow some of these reserved matters to vest in the board. That means the board of directors can decide on these matters provided that you get unanimous consent of the board. For example, creation of charges or other encumbrances, borrowing of monies, starting lawsuits, formation of subsidiaries or acquisitions of other companies, change of business scope, diversification, opening bank accounts, or appointing authorized signatories. These are less important things which should not ideally concern the shareholders. Appointment or removal of or change of auditors, sale, transfer, license, grant of trade secrets, intellectual property of the company, change in the size of the board, incurring any expenditure above the budgeted amount, entering into, terminating, amending any material contract, approval of the budget of the company. So these are not so important reserve matters that can be vested into the board. So thanks for watching part 3 of this series on shareholders agreements. Stay tuned for the other videos to come.